So today we'll start with another thing, that is no fault liability. I guess you have already studied that, right? Unit 3. When we started, I guess this topic was going on in your college. There are two concepts, strict liability and absolute liability. So what is no fault liability? In general, when we studied about elements of tort, what we have seen is there will be some kind of an act or omission, right? There will be a wrongful act or omission that will lead to legal damage. That means violation of some legal right, like right to vote and stuff. And that should create or give us a legal remedy as well, right? Law only should allow us to ask for compensation or other types of remedy or relief. That is the general concept what is taught. Then last class we saw about vicarious liability. What is vicarious liability?
Like what to say, master and servant relationship, principal and agent.
So someone else can be made liable for somebody else's tort also, right? First general concept is if you are doing anything wrong, you will be answerable for that, nobody else. But vicarious liability says even if you are doing something, someone else may be made responsible based on the relation that exists between you both. And then thirdly, we have this concept of no fault liability. So what is no fault liability? No fault.
Like even we have done anything, but we not liable for that, ma'am.
Even we have not done anything, then we are not liable.
No, ma'am. Even we have done something wrong, but we not liable for that, ma'am.
Is it, or you are saying the opposite? No fault liability.
Ma'am.
You have done something wrong or you have not done something wrong? No fault liability.
Ma'am, actually I am a little confused on that.
Okay. So as the name suggests, right? What is it? No fault liability. Liability we all know, right? What is liability under law? You will be made liable to maybe pay compensation in most of the cases, right? So you will be made liable, right, for compensation, for injunction, for whatsoever may be the relief. But when you will be made liable, even when you have no fault, right? You have not done anything wrong, but still you will be held liable. That is no fault liability. Because in general, if you have done something, obviously you will be liable. That is the general concept of tort, right? But this is an exception, right? It says even if you have not done anything wrong, you will be held liable, right? You can understand it from this name also, no fault liability. There is no fault on your part, still you are held liable, right? So regarding no fault liability, there are basically two principles that we need to study. One is strict liability, another one is absolute liability. Okay, so strict liability as in, like we say, right, this is a strict teacher, right? You cannot, maybe you cannot discuss with your friends while answering, right? What is strict? That means they would, like they would look at everything, right? You cannot just escape or something like that, right? So that is strict. That means you will be held responsible if you are talking in class. If you are doing something else, you will be held responsible. That is like a strict teacher, same strict liability. All right, mostly you would be held liable. What is absolute? Absolute, what is absolute? Like complete, right? There is nothing left. Absolute as in like completely, there is nothing left after absolute, right? So when we say absolute liability, that means there is no scope for you to escape, right? You will be held absolutely liable. You cannot escape from there. But even if someone is strict, you can still talk to your friends. You can still find some escape ways, right? You can still manage to do some few things. But in case of absolute liability, you cannot do anything. You will be held liable for it, like completely, absolutely, you will be held liable. All right, like that, you can remember these three concepts. No fault liability, even if you have not done anything wrong, you are still held liable. There are two concepts under no fault liability. Strict liability, wherein you will mostly be held liable, but you can still manage to escape few things, right? In case of absolute liability, you do not have any escape ways, you will be held liable, right? These three concepts we need to remember, and after that we would study what is strict liability and what is absolute liability. Right, so strict liability. This concept was developed in this case, Rylands versus Fletcher. So you remember what happened in this case?
Like
Whatever you remember, you can say.
ma'am, actually, like mill will be there, like the water will flow on that. Something I don't
Yeah,
remember.
mill will be there, water will flow, right? Where it will flow?
Two neighbors, like mill,
Yes.
ma'am, rice
Yes.
mill.
Yeah. And then what neighbor will do?
Like neighbor will go for court, ma'am, like for compensation, I think, ma'am.
Yes, neighbor will go to court for compensation. Right. So Rylands versus Fletcher, there were basically two neighbors, right? Rylands and Fletcher. Rylands owned a mill and Fletcher also owned some similar thing he also owned, right? So Rylands owned a mill, and for that he needed a lot of water, right? To meet the energy requirements and everything, he needed a lot of water. So he thought that I will construct a reservoir inside my premises only so that I can store water there and I can use it, right? For requirements of my mill, I will be able to use it whenever needed. Now, for this construction purpose, what he did is he hired some independent contractors and engineers. So, who are independent contractors?
Ma'am, he had given work for another.
Like from vicarious liability, we saw, right? Solvent and independent contractor. Who is an independent contractor?
Ma'am, we will appoint somebody, ma'am, but we not use it to guide them, ma'am.
Yes, right. We will just tell what is to be done. Like he will say, I want this big a reservoir to store water, right? But he will not be giving instructions, do it like this, do it like that. So he hired some independent contractor and engineers, and he told them what is to be done, that you need to construct a reservoir over here to store water, right? So accordingly, work was given, but he was not supervising or monitoring it that much. When those independent contractors or engineers were constructing it, they found out some old unused coal shafts lying there. So what is it? Old coal shafts, which is not being used. So it is something like this, okay? Basically, like to extract coal, right? There will be some these kind of things. So there was these sort of shafts lying there, which are unused, right? Previously it was used, but now it was unused, right? So when those engineers or contractors, they saw these old coal shafts lying there, they should have ideally properly like closed it, right? Properly sealed it and everything, right? But what they rather did is they simply just filled it, like without properly like sealing it. They just simply blocked it, and they just did their work, right? They had to construct a reservoir, they just constructed it and they left. But now, after this construction work was being completed, after this construction was being completed, Rylands wanted to store water there. When he stored water in a very huge quantity, what happened is water escaped from his premises through this old coal shafts to his neighbor's premises. Right? He was having a mine and this person was having a mill. So it caused heavy loss to this other person, Fletcher. Right? And as a result, Fletcher went to the court and he filed a case asking for compensation. Right? That this person has done this thing wrong and I should be paid compensation because I have suffered loss. In this case, for the first time, Ford developed this concept called strict liability. Okay, so it was developed that there is a concept called strict liability. What happens in this case is, if, right, you satisfy these ingredients of strict liability, you will be held liable. All right. So what were these conditions? First of all, you are keeping some dangerous thing within your premises, right? What is dangerous thing? It may be some harmful chemicals that you are storing for the purpose of any manufacturing or other work. Maybe you are storing some disease producing germs because you are doing some research on that. That will also be dangerous thing, right? Whatever is usually dangerous, that is the anyways dangerous thing. Other than that also, right, if any usual thing also you are storing in a huge quantity, right, that if it escapes, it will become dangerous. In that case, that thing also may become dangerous. Like if you are storing water in a very huge quantity, if it escapes to your neighbor's place, definitely it is going to be dangerous, right? So water can also be dangerous. Some other stuff can also be dangerous. If you are storing it in a huge quantity, if it escapes, it would be dangerous for your neighbors or other people around, right? So first thing is that dangerous thing you are storing. It may be non-natural use of land or storing anything for special use of the land. Like usually what happens in a residential area, we would construct a house, maybe to store water, we would construct like a water tank, right? Or we would buy a water tank rather, right? But if you are storing water in like, like thousands and thousands of liters, right? That if it escapes, it is going to be very dangerous for your neighbors or other people around. In that case, we would say that it is a non-natural use of land. Ideally, you would not be storing that much of water for your regular use, regular consumption, but you were storing so much of water that it is considered as a non-natural use of land, right? In that case, the person would be held liable. Secondly, it should escape, right? If water is within your premises, your neighbor comes and jumps in that water, that is not the case. You would not be responsible. But if it escapes from your premises, only in such a case you would be held liable, right? So you basically need to satisfy these two conditions. You were keeping some dangerous thing, or you were making non-natural use of your land, right? That is the first condition. Secondly, whatever you were storing, that things should escape from your premises, right? If these two conditions are being satisfied, what happens is prima facie liability of the person. Prima facie as in it's very clear. You don't need to prove anything else, right? It escaped from your premises means you are liable for it, right? That means prima facie liability will arise whether defendant has fault or not. Court is not going to see whether you were negligent, whether your fault was there or not. Court is just satisfied with the fact that you were storing some dangerous thing within your premises and it escaped from your premises and caused some loss or damage to another person, right? So if these two conditions are satisfied, these first two grounds are satisfied, defendant will be held responsible. There will be prima facie liability, right? From the very fact that it escaped, we can hold the person liable. You don't need to prove anything basically. Okay, is it clear?
Yes, ma'am.
So that is the rule of strict liability, that if you fulfill these two conditions, storing dangerous thing or non-natural use of land, and secondly, it escapes, it will lead to prima facie liability of yours, right? That is the general rule. But what happened is there were certain exceptions to this rule, right? What were these exceptions? So what were these exceptions here? It said plaintiff's own fault, right? That means you, like whoever is going to the court asking for compensation, that person only was responsible. He only was doing something wrong, right? Like there was one case where what happened is there were like wild trees one person was growing inside his premises, right? So if this is his campus, he was growing these wild trees within his premises. And these wild trees did not escape from his premises, all right? But his neighbor was having few horses. Those horses entered his premises and they ate those, like leaves and other stuff, and then they died. So this neighbor filed a case and the person said that it did not escape from my premises, right? Whatever wild trees I was growing it inside my premises. It did not escape. So I am not responsible, right? That is an exception. If it is not escaping from your premises, if the second condition is not satisfied, you will not be held responsible, right? That is the first exception which we have. Secondly, act of God, right? If natural forces has played some part, might be you had constructed a swimming pool, all right, on top of your like building, you constructed like a very big swimming pool, right? Now, constructing a swimming pool also is not like a natural use, right? Ideally, people would not construct that, but you were doing it. That's completely fine. But now, if it escapes from your premises, that water, right, you will be held responsible. But if it was because of act of God, might be someday it was like a very heavy rain or some earthquake, this, that, it is something like unpredictable, all right, and it happened. You had constructed it properly only, but it was such an, like unexpected event that it just led to damages with regard to that, like swimming pool, and it caused loss to the neighbors. In that case, the person can say that, yes, I did construct a swimming pool, water escaped from there, completely true, but it was because of act of God. It was some like something which I could not have even expected, right? Like that it happened, and accordingly it led to the destruction. In that case also, person can escape, right? Because it was not my responsibility, but it was act of God. So even if these two conditions are also satisfied, you can still claim for this defense, right? It was act of God. Thirdly, mutual benefit or voluntary non-fit injuria. What is voluntary non-fit injuria?
Voluntary accepting the risk. No?
Voluntarily accepting something, you will not be fit for asking for compensation, right? So if I was constructing a swimming pool, okay, fine, I was doing non-natural use of land, but you also agreed to it. You also said, yes, you construct the swimming pool, I also will be coming and like taking the benefit of this pool. In that case, if water escapes from my premises, you cannot complain about it. Why? Because you only consented ki yes, you construct, I will also be using. You also were taking benefits, so none of us can complain about it because there was consent from both of us, right? It is like mutual benefit. Both of us were using it. Thirdly, wrongful act of a third party. What is wrongful act of a third party?
Ma'am, like ma'am, some strangers are
some strangers, yeah. Some strangers will do what?
Ma'am, we not liable for like something done by strangers, ma'am.
Yes. Again, we will not be held liable for something that is done by a stranger, right? So what happens is, take for example this case only, right? I was growing like wild trees within my premises, right? But it was like a properly closed space, right? There was proper, like boundary wall, gate was closed and everything. But even after that, if some stranger comes and he maybe breaks the gate or something like that, as a result, some horses comes, they eat or something, right? I can say that it was wrongful act of a third party only. Yes, I was growing wild tree, but it was within my premises only. I did ensure that I'm properly closing the space with boundary walls, gate and stuff. But some third party came and they broke that, like that gate or stuff. And as a result, only some horses or other animals entered and they ate the leaves and stuff, right? So that means wrongful act of a third party. Somebody else did something, some stranger did something, so I should not be held liable. But I should take the reasonable steps, right? Like if I'm growing wild trees, maybe I would properly keep the area closed and protected, right? But if someone comes and they break that gate itself, in that case, I cannot do anything, right? That would be accepted. But if I'm only just keeping the gate like that, not even locked, someone just comes and hits it, it gets opened, that would not be the case, right? I should take my best care that I'm properly closing it and stuff. After that, someone is doing something like breaking the gate, I would not be held liable, right? That is wrongful act of a third party. And last one is statutory authority, right? If government is doing something, as a result, something happens like National Highway Authority of India constructing a highway, widening a highway, something goes wrong, right? They would again not be held liable. If under their own rules or provisions, there is something that this is like a minimum compensation will be provided or something, that they will provide, but otherwise not like a very high liability or something, right? So these are the exceptions that we had available in case of strict liability, right? That if these two conditions are satisfied, you have prima facie liability, but even when you have liability, you can try to defend yourself by proving any of these 5 grounds. All right, is it clear?
Yes, ma'am.
Now, like these are like so many grounds, like 5 different grounds, and it covers almost every aspect of it, right? So what happened is, even though this rule was developed in Rylands versus Fletcher case, it was observed that many a time, right, people would prove either one of these 5 exceptions, right? So it was very easy for people to escape. Even though we had this rule of strict liability, it was very easy for the like the person to prove any of these defenses and just escape from their liability. As a result, what happened is a new concept was developed in India. So it was developed in this MC Mehta versus Union of India case, which is also known as oleum gas leak case. Right? What happened in this case? Do you remember anything from this?
Ma'am, like even like Bhopal gas tragedy, that's like, ma'am.
Bhopal gas is also another one. This oleum gas leak is regarding a gas leak that another one, okay, regarding this leak of oleum gas. Okay, what happened here is, it was a case from Delhi. All right, in 1985, there was leakage of oleum gas in the month of December 1985. Right, so this incident that took place was in one of the units of Shriram Food and Fertilizers Industries that belong to Delhi Cloth Mills Limited. Right, as a result of it, there was one advocate also who died, and there were like damages suffered by other people also. Right, as a result, a public interest litigation was filed in the court, say like asking for compensation, right, raising this matter. So in this case, right, court basically observed that whatever this rule of strict liability we are having, it's still very easy to escape from liability, right? So as a result, they developed this new concept of absolute liability. Okay, so what is absolute liability? It basically says that it's basically like strict liability only, but minus the exceptions. Right? If we minus the exceptions from strict liability, we will get absolute liability. So all these exceptions that we have, these will not be present here. So what are the elements for absolute liability? If there is some enterprise, right? Like in this case, this Delhi cloth mill, right? Like that, there are so many, like Bhopal gas leak tragedy that you said. Recently, there was one, right? In 2020 only, Visakhapatnam, there was gas leak, right? During starting of lockdown, right? So there are so many cases like this, right? So what happened is, as a result, this concept was developed, right? Absolute liability. It says, if there is an enterprise which is keeping some dangerous thing, because usually it would be some enterprise or some factory who would be keeping in such huge quantity, right? So if they are keeping some very harmful things in a huge quantity, and as a result, it escapes from their premises, right? And it was like a non-natural use of land, keeping such a huge quantity of dangerous things. It is non-natural use of land. If it escapes, they will be held liable, right? You cannot prove any of these points, even though it was not your responsibility, even though it was some third party who did something, even though it was act of God, mutual benefit, wrong, statutory, whatever it is, it's not concerned. You will be held liable if it escapes from your premises, right? That was the concept which was developed regarding absolute liability. So there are basically these elements, right? We cannot just escape by proving any of the defenses that we have. And how compensation will be decided here is depending on the magnitude and capacity of the enterprise, right? Because we do not know what would be the size and like how big the enterprise will be, right? If it's like a very big enterprise having their branches across India, and some compensation is being asked that, okay, fine, you pay 50 like 50 lakhs compensation, it might not be anything for them, right? They would simply pay, okay, fine, take it. In that case, they would not realize it, right? Like how big loss they have suffered. They would not realize it because that compensation amount is like very minimal for them, right? So as a result, in this case, it also said that measure of compensation, right? While deciding the amount or quantum of compensation that is payable, what we should do is we should look at the magnitude and capacity of the enterprise so that the same can have deterrent effect. That means we will look into the size and capacity of the enterprise, right? How big the enterprise is, what is the size of that enterprise, accordingly compensation would be fixed, right? If it's like a very big organization, accordingly big amount of compensation would be fixed so that it can have deterrent effect. That means so that they realize it, and other such companies also would be afraid that, okay, fine, we also need to take care of it, right? We also need to ensure that we are not doing anything, we are also not negligent and stuff, right? So that is the principle which was developed. Then Bhopal gas leak, as you said, there was leakage of this methyl gas, right, in such a very like a huge quantity, right? And then it led to death of around 3,000 people. So many people sustained loss, injuries and stuff. So as a result, court asked for compensation, right? That the company need to pay compensation in order to undo the loss or the harm suffered. Same happened with regard to that Visakhapatnam one also. I think investigation is still going on. But when that incident took place, government announced some compensation and the company was also asked to pay some initial compensation, and then investigating team was formed. They were investigating on the matter and stuff, right? So how that could happen? Because you cannot prove any of these points and simply escape liability, but it will be held responsible if these conditions are being proved, right? So accordingly, the compensation amount will be fixed and they will be held liable to pay it. So is this part clear?
Yes, ma'am.
So any doubts, anything?
Ma'am, for this absolute liability is there, ma'am. Whether we want to write that MC Mehta versus Union or Bhopal gas.
See, MC Mehta you need to write because in this case it was developed, and after mentioning these things, right, development, I will also add that Bhopal gas leak thing also, where compensation was actually provided and stuff. So that also you can write. Okay, anyways, these cases are simple. You already remember the things, right? So I will add that also, and you can write that thing also. Okay. So these documents that I'm sharing, you can just go through these just to keep these topics fresh. But when we are discussing questions, right, how you need to write the answers and stuff, that time I will include maybe 1 or 2 more cases. Okay, that also you can write in exam.